Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, as you know that we are carrying a very interesting series on intellectual property rights, and so far we have conducted many lectures, and in our previous lecture we talked about laws relating to patents in India. Dear friends, in this session today we are going to talk on laws relating to patents in India. Definitely we are going to cover from the point where we left in our previous session, as well as we are going to talk about subject matter of patents in India in another half of our session. So dear friends, without wasting any time, I would like to welcome our subject expert, Mr. Ashwani Sewal. Mr. Ashwani Sewal is Assistant Professor in Faculty of Law, Delhi University. So dear friends, let's welcome our guest, Mr. Ashwani Sewal. Mr. Sewal, welcome to the
Thank you very
lecture.
much. Good morning, viewers. Well, as Gitika rightly mentioned that we started specific intellectual property in our previous lecture, that is patents or law relating to patents in India. Well, viewers, today we are going to continue our earlier discussion where we left in our previous session. Along with that, as told by the Gitika, that we are going to discuss a very specific concept in the law relating to patents, wherein we will deal about the patentable subject matter in India. See, the law relating to patents in India is the Indian Patents Act 1970. Viewers, under this act, there is a provision that does not give us the detail what are all inventions. Rather, this particular act, through this provision, that is section 3 of the Indian Patents Act 1970, provides us a negative list, or you can call a list of non-patentable inventions which cannot be given a patent protection. So this may be very, or they may remain very interesting for the viewers today. But before that, viewers, I would like to finish my earlier discussion. Let me recapitulate certain points one by one where I discussed the basic principles relating to law of patents in India and the fundamental concepts about the patent law in India. Viewers, if you remember and recall properly, in our previous lecture, I talked about the meaning and concept of patent. I discussed this topic in very detail, wherein we understood the concept of patent and its meaning. For your recall in your memory, I would like to tell you that patent means open and its antonym is latent, which means hidden. And as I discussed in my previous lecture, that patent derives its origin from a Latin term, later patents, which I discussed in a very meticulous fashion in my previous lecture. The next thing, if you remember and recall, it was history relating to patent law, not only in India. I covered the history of patents in US, history of patents in UK, Europe and India too, wherein I dealt with classical period, I dealt with the European origin of the patent law, and then the British origin of the patent law, as well as the Indian origin and evolution of the patent law in India. If you remember, viewers, as far as the India is concerned, we had our patent law, pre-independence patent law, in the form of Designs and Patents Act 1911. That was purely what? That was purely based on the British laws. After the independence, post-independence, that continued for 2 decades. So we were primarily governed by the British law, or say you can say a facet of the British law in the form of 1911 Act till 1970, when we got our Indian Patent Act 1970 enacted, which is still operative. And as I mentioned in my previous lecture that it has been amended so many times, the celebrated amendments were discussed by me in my previous lecture, wherein we had the amendment in the year 1986, we had the amendment in the year 2002, and then we had the amendment which I call a very important amendment in the year 2005 in terms of pharmaceutical, or from the perspective of the pharmaceutical industry. That amendment is very important and crucial. Friends, if you remember in my previous lecture, I talked about the philosophy of patents. premise or two basic beliefs I discussed on which the intellectual property regime revolves as far as the philosophy of the patents are concerned in India. One, consequentialist approach or consequentialist philosophy, which talks about that the patent or the patent regime is primarily for the purpose of welfare of the masses, primarily for the purpose of benefit of the masses at large, because the philosophy of the consequentialist theory talks about that patent is not to be seen as to whom it is to be granted or to whom it is to be conferred, but its consequences after conferring to an individual or to an entity are to be taken care of, are to be considered. If the consequences are for the welfare of the people, then that patent is for the upliftment and for the benefit of the people, and that is how this philosophy, which is called a consequentialist approach, wherein the consequences are to be seen, not the rights to be conferred on the people. The another approach, another philosophy on which the patent is deemed based or primarily considered based, that is the theory of natural right theory, which we call does not care about the consequences of conferring of the patent to an individual. That only discusses that the person who is a creator, who is an inventor, if creates something, if invents something, he has to be given his natural right over his creation, no matter, notwithstanding, irrespective of the fact that the consequence of that grant or that conferment will be detrimental to the society or will be harmful to the society at large. These are the two philosophies on our patent regime generally is based or basically discussed to be based. Another thing that I discussed in my previous lecture, if you remember viewers, that was relating to economics of the patent laws. Friends, patent law plays a very important role as far as the economics of the patent or its relation with the economy of the country, of the nation is concerned. It is proved fact that patent does facilitate the exponential growth of the economy of the nation. It facilitates individuals' well-being or the creator's well-being in terms of giving or in terms of getting or fetching royalty to him through his invention, and as far as the masses are concerned, they also get benefited when they are told about the or when they are disclosed about the invention and its benefits or its working as such. Moreover, when we talk about the economics, friends, let me take you directly where we left in the last lecture, that was relating to economics of patent laws. Friends, the research in economics demonstrates the link between intellectual property and the growth of our national economy. Generally, it is said that patents do create monopolies, but this is not necessarily correct. As written in this slide, I will explain this concept why it is not correct, along with one of the judgment cited by me here of Mr. Judge Rich in his famous 1942 series of articles in US. Friends, we generally consider that patent do create monopoly, but it is not true as mentioned in this cited judgment by Mr. Judge Rich. Otherwise also, if you would try to analyze that patent which is presumed to be a monopoly is not a monopoly, or necessarily it is not a monopoly, because no person who is owning a patent can ever in any case get a market dominance in one particular good or in one particular product or in one particular process. It has never been possible. No matter the entity is possessing many patents, it's owning lot of creations and inventions, and patents are there on those inventions and creations. Still, despite that fact, irrespective of that fact, the monopoly will not be granted to him, or he will not be enjoying the monopoly, because the patent right which gets conferred on a person when he or she gets the patent it primarily gives the right to the person to exclude others by making use or unauthorized use of that patent. Others are free to come up with the similar kind of inventions, are free to come up with the, I am not saying that they are free to imitate the work of the creator, they are free to work hard, work more on the similar kinds of works which can be granted the patent or which may go to the dignity of getting the patent protection if that particular thing will qualify the substantive requirements for obtaining the patent, which we will discuss later. I mean the requirement in the form of novelty and non-obviousness. But the point is that the patent does not grant a monopoly as such. As said in this judgment, if you read it, it says, indeed it has become conventional to say that a patent is a monopoly. Nonetheless, it is readily apparent that the right to exclude another from manufacture, use and sale may give no significant market power, even when the patent covers a product that is sold in the market. Without the benefit of empirical research, it is entirely plausible to conclude that in the great bulk of instances, no significant market power is granted. We must bear in mind that leading companies may obtain 1,000 or more patents in single year, and yet many such firms are unlikely ever to obtain even a single monopoly in any market. This sounds very clinching, that even after obtaining 1,000 or more patents in single year, a firm may not obtain even a single monopoly over that product or that process in an year. He or she gets the exclusive right to work or exclusive right to exclude others, automatically, impliedly to work on that particular thing. That right does not get conferred by the patent law or the patent regime, but the right which gets conferred on the person is to exclude others, is to negate others if they unauthorizedly try to trespass, impede on your work. Then in that case you can always apply your patent or go for the enforcement of it. The point is that it does not grant the monopoly as said in this judgment beautifully. So whenever we talk about that patent is a monopoly right, we'll have to think, pause for a moment and think and analyze whether it is really a monopoly or it is just a facade which is created that it is a monopoly. Well viewers, the next area that I am going to deal today, what is the justification of granting a patent? If it is considered as a monopoly, if you say, suppose, for a moment consider it as a monopoly, is it justified to grant patent if it is a monopoly? And what is so clinching, what is so promising that the government still grants the patent protection? So as far as the justification for the patent is concerned, viewers, there are two rampant views which are to be taken into the consideration, which are to be discerned, comprehended by the viewers or by the reader of the law, especially the patent regime in India. The first justification which says or which primarily revolves on the point that patents are not for the good, patents are bad, patents are for the exploitation, patents create monopoly, patents raise prices, and the benefits are appropriated by big business houses. Let me explain it little bit, viewers. See, this justification or this view posited by some of the thinkers, which goes not in consonance or not in compliance with the patent regime, it goes opposite to that regime. It says that patents exploit, they create monopoly, it raises prices, it benefits only the affluent, it benefits only big business houses, it caters only big business houses. Friends, some of you may be thinking that this proposition or this trajectory posited by the thinkers giving the justification or idea about the justification of the patent seems right. Many of you may concede to this argument, may concede to this theory posited or this argument posited by the thinkers. But many others may give their dissenting opinion as far as the justification for the patent is concerned. And this is what happens because many other opposite views are also available when we talk about the justification of the patent. If you have a look on the opposite views, which says that it favor patents to primarily that the patents protect, it produce and promote knowledge by disclosure, etc. If you see both these trajectories, both these propositions, it will be really very difficult for a person to stand by side of one view or to vindicate one particular view, because both seems clinching when one sees these two views superficially. But I will not ask or insist any of my viewer to go with one particular view. I'll always keep it open to the viewers to discern, think, analyze, study, research on these two rampant views with us, and then finally make their mind to go ahead with their supposition, with their primary thought and with their primary consideration. To my personal view, the later view posed by the thinkers, wherein they say, wherein they favor the patent regime, wherein the thinkers do not oppose the patent regime, to me the later view is very clinching, because it says that the patent granted to the person is for the disclosure of that particular invention. As discussed by me in my previous lecture, viewers, that whenever you get a patent protection, by applying for the patent, it is a mandate of the office to first of all declare it, disclose it, or the details in the form of the specification are to be disclosed to the public, which will let open by the government agency, which is a controller of patents in this case, through the publication into the public domain, so that public or the people engaged in that research may come to know that there is no need to further research in that particular area, as it has already been granted a patent, as it has already come into the existence through this and that person or by this and that organization. Another important facet, another important feature that I find very clinching when we talk about the later view which favors the patent regime, is that patent gives an incentive to the person. It is a reward to the creativity, to the labor of the person, to the judgment and skill applied by that person when he came up or comes up with that particular creation and invention. Had he not been given or had he not been promised with this kind of an incentive, a reward which he primarily looks forward to, he would not have created anything, or he would have created a thing which cannot be granted a patent protection. So it's better to have such a regime which at least gives an incentive and a promise to the person, at least promises to the creator, to the inventor, that he or she may fetch some sort of incentive, a reward, an exclusive right when he will create something, he will produce something. That keeps him going on and on. Work keeps him giving motivation to work more and more. So it's up to the viewers and the listeners to decide and to think, analyze, and finally go with one particular view, or maybe they can, research on this area forever to make their view or to discern or to understand which view is more cogent, which view is more promising to their understanding and for the public at large. Well, viewers, I will take you to another important facet, another important thing which must be understood by all my viewers or all the people endeavoring to learn about the patent regime in India. Viewers, the patent regime in India talks about two kinds of patents. The third kind is also there, which I will discuss. The first two kinds, which are apparently explicitly written, as well as the third kind is also explicitly written, but the third seems a new or kind of a mixture of both the earlier kinds. Friends, when we talk about the term and the types of the patent, let me take you to the slide wherein I have given a beautiful description about the types of the patent in India recognized by the Indian Patents Act 1970. The first is the product patents given to a product created by the creator, inventor, because patent is always granted on an invention. Obviously the person who invents it is the inventor. It is a product patents. The another one is process patents. Friends, as the name suggests, even to the process a patent can be granted. It is not only to the product or the final outcome of your application of mine, or say final application of the series of actions taken by you. It is also to those series of actions that a process patent can be granted. Means the process applied by you for creating something, for manufacturing something, can be granted a process patent protection. The third kind recognized by the Indian Patents Act 1970 is product by process patent. That is very technical, that sounds very technical and tricky. Friends, it seems as the name is shown as if it is a combination of earlier two. In fact, it is a combination of earlier two. So keep in mind that these are three kinds recognized by the Indian Patents Acts. As such, Indian Patent Act does not provide any provision or does not provide any section talking explicitly apparently about the kinds of the patent. But when we read the patent law, its provisions or its language, we find mention of these three kinds of patents to be granted or conferred on the person. One is product patent, another is process patent, and the third is product by process patent. Let us take some examples of the product patent. These are some of the historical examples of the product patent. You can pick up many more examples if you will start searching about the patent, product patent especially, and when you will start reading about the patent law. Snowboarding is one of the newest sports in the games. Many point to this patent for a monosky. It was awarded to Robert Weber in 1973 as the first registered board. Isn't it very interesting, viewers, that a monosky was given a patent protection, and it is a sports activity on which the patent was not granted. Kindly keep in mind that it is not to a sport activity the patent was granted, it is on this product which is a board which is named as monosky is given a patent protection, and it is a product which is given a patent protection. Let us see its specification for the snowboard. That is how the inventor, the producer of the work, the creator of the work has to give the specification, the meticulous details, the subtle details of the patent, of the working of the patent, to enable others. Others here mean the people who are engaged in the similar sort of activities, people who are ordinarily skilled in that particular art, to enable them to work upon that, or to enable them to at least enable them in a situation where they can on their own create the similar kind of a snowboard. And that's the purpose, that's the whole point, whole agenda of the patent law, to keep it open, to disclose it to the public and giving its benefits to the public, irrespective that the monopoly to exclude others, to make manufacturers sell or offer to sell, has been restricted to the creator for 20 years, but after those 20 years it has to fall to the public domain, and before that, while applying for the patent protection, this specification has to be left into the public domain open to be read by the other people who are skilled in that art and maybe other interested people. Let us take another example of the patent product, a patent for a ice surfacing machine. This is the specification of a ice surfacing machine. It was awarded to Ephonymous Frank in 1953, and this by the year 1960 was invented a model using an auto chassis. See, this is a ice surfacing machine which is a product, and it is a patented product over which a person owns a patent. There can be many other similar to that which you can very easily find out when you will research about the subject. Let us see another example of the patent product. Here the sky lift was awarded a patent for a sky towing device in 1939. It is a sky towing device which is granted a patent. So these are some of the examples of the product patent, and the specifications are beautifully demonstrated in these slides so that viewers can understand that whenever they think of applying for a patent, if they have created something which they think falls or can be given a patent protection or falls under the ambit of the patent regime, in that case they are ideally supposed to specify their work in this manner in such beautiful details to the patent office. Only then the patent office will be conferring the patent office. Well, viewers, let us take some more examples of the process patents. A process of making pharmaceutical composition can be granted a patent because there may be a process which manufactures or which creates a drug in a very speedier manner vis-a-vis to the earlier manner of making a pharmaceutical composition. In that case, or maybe in many other manners, say a process is having some inventive step involved in it, I mean something which is not already in the public domain, which has not been published anywhere in the world at large. If that kind of a feature is involved in your work, that is a process, can be granted a patent protection. Another example where a person can be granted a patent protection, a novel process for the manufacture of pure and doped bivalent metal sulfide nanopowders. It is quite technical for the viewers who are not from the science background or who does not know about the medical terms, but you can pick up the earlier example to understand a process of making pharmaceutical composition, a process of making anything. A process means some actions or some series of actions are taken by the person to come up with the end product. Those series of actions together or one of the aspect of those series, out of those series of actions, may get the patent protection if that particular portion or that particular part or the entire process, if possesses the requisites to be fulfilled, possesses or fulfills the substantive requirements or procedural requirements for obtaining the patent. Viewers, I will take you to another thing. As far as the term of the patent is concerned, let me tell you that the term of the patent in the Indian Patent Act is given under section 53 of the Indian Patents Act 1970. Friends, if you see the language and the first subsection of section 53, which reads that subject to the provisions of this act, the term of every patent granted after the commencement of the Patents Act 2002 and the term of every patent which has not expired and has not ceased to have effect on the date of such commencement under this act shall be 20 years from the date of filing of the application for the patent. I would like to draw your attention here for a moment, viewers. It reads that it would be 20 years from the date of filing of application for the patent. So your term starts the day you file the application for the patent. The term for the patent does not commence, does not begin on the day of the conferment of the patent protection. It starts rather from the day the application for the patent or for the obtainment of the patent was filed by the applicant. That has to be taken note of by the viewers or the people interested in knowing about the patent law, that it starts the patent duration, the span for enjoying the patent or the exclusive right given under the patent starts right from the day when you apply for the patent protection. It's not from the day when you get conferred with the patent protection. Well, viewers, let us see another interesting area. We are almost done with the basics or the concepts of the patent or the patent regime in India or otherwise. I am taking it to another important area wherein I am going to start what all can be given a patent protection, what is patentable and what is not patentable, what the law says in that regard, what the Indian Patent Act 1970 says in that regard. But before that, friends, I would like you to see some of the essentials for obtaining the patent. Unless you know these essentials, you will never be able to understand, you will never be able to know the nuances involved in the Patents Act 1970. Friends, the first essential to be seen as far as the Patents Act 1970 is concerned, when it comes to obtaining the patent is concerned, we will have to look at the substantive requirements for obtaining the patent. If you know the substantive requirements for obtaining the patent, then you can easily go for the procedural requirements for obtaining the patent, which always ensures the, or which always comes later, or which always follows the substantive requirements to be fulfilled by the person. Procedural requirements comes later, after fulfillment of the substantive requirements. If the substantive requirements remains unfulfilled, remains unsatisfied, no matter you comply properly with the procedural requirements, you cannot get the patent protection in that case. So what is important and what is to be taken care of by the people interested in obtaining the patent? That the substantive requirements are first of all fulfilled, and then there has to be a compliance towards the procedural requirements. So I'll tell you what are the substantive requirements for obtaining the patent. Let us see, friends, the very first thing when we talk about the essentials for obtaining the patent, the very first thing is that the invention must not have been excluded by the Patent Act as non-patentable. We must see that the invention must not have been expressly excluded by the Patents Act as non-patentable. Friends, this requirement falls under the substantive requirement. I am talking first of all about the substantive requirements, then I will jump to the procedural requirements. The first thing that has to be checked, that has to be seen, that has to be primarily satisfied on the priority basis by the person interested in obtaining the patent over his work, is that his work should not be the work which is expressly excluded by the Patents Act 1970 from the purview of granting a patent protection to it. If his or her work falls under that list, which I call a negative list, or which I call a list comprising non-patentable things, comprising those inventions which cannot be granted a patent, if the work of the person, interested person seeking, aspiring to get the patent protection, is falling under any of the enumerated subject matters, he or she can never be able to get the patent protection. We will see it in a very exhaustive fashion, what all comes under that definition, what all is excluded by the purview of that definition, what all cannot be given the patent protection. But the thing that I wanted to tell to my viewers, and I wanted to make them understand first of all, is that they will have to see whether their work is a work which is not in the purview of the excluded matter, which is not in the purview of the expressly excluded subject matter. If it falls under that, it is a thing that cannot be granted a patent. The another substantive requirement to be seen and gauged by the person, that it must be in respect of a new product or process. That has to be taken care of by the person interested in obtaining the patent, that his invention must be in respect of a new product and process. I would like to draw your attention here, viewers, that the word new is prefixed with the word product and process here. In the Patent Acts 1970, under the definition of the word invention, under the definition of the word new invention, it is mentioned that new invention means a new product or process. So this is another important substantive requirement to be fulfilled by the person seeking to obtain the patent protection, that his product or process over which he is thinking of getting the patent protection is new, means it is novel. You can say it is novel, because the term novel as such specifically not been used in the Patent Act, but when we see the most important international instrument relating to intellectual property, which is TRIPS, that is trade related aspects of intellectual property, agreement relating to trade on intellectual property, it uses the word novel, but it does not obligate any member nation to use this similar word, but it obligates as far as the compliance of these basic tenets are concerned. So we use the word new invention instead of the word novelty. Novelty is being used by many jurisdictions. For example, United States uses the word novelty in its legislation relating to intellectual property, in its legislation relating to patents. But India does not use the word novelty, but it requires the same qualification to be fulfilled, same requisite to be fulfilled, same substantive essential to be fulfilled, which is novelty, but worded in a different manner, that says it has to be a new product or a process. If it is not new, if it is not a new process, if it is not a new product, as per the definition given under the Patents Act, in that case it cannot be granted the patent protection. The another requirement, it must involve an inventive step to ensure its non-obviousness. Viewers, it is very interesting to note here that the third essential or third requirement put by me or shown by me in my slide reads that your invention must involve an inventive step. It must involve an inventive step. If it does not involve an inventive step, it lacks the patentability, it lacks the qualification to fetch the patent protection, it lacks the requisite for obtaining the patent protection. As far as the word inventive step is concerned, in the Patents Act 1970, this word has been defined under the definitional clause under section 2 of the Patents Act. We will see the definition, we will discuss it in a very detailed fashion, in a threadbare fashion. But before that, I would like to make it clear to all my viewers that this requirement in the form of an inventive step is very popular and very stringent requirement to be fulfilled, is very rigid requirement to be fulfilled. You can say and understand that granting a patent or the qualification for obtaining the patent has been put on a very high threshold vis-a-vis to low threshold in the cases of the copyright, in the cases of other intellectual properties. This qualification, this essential requirement of proving the inventive step involved in your work is, as I mentioned rightly, is very stringent, is very rigid, and it is known in many nations as a requirement of non-obviousness. Superficially, I would like to discuss it right here, right now to my viewers or with my viewers, that this requirement requires the inventor to prove that his work, his invention is not obvious, is non-obvious, is is involving an inventive step, some technical advancement in it over the earlier work when it comes to a person skilled in the art, when it comes to the person knowing about that art, knowing about that particular discipline. So these are some of the substantive requirements. We will going to discuss them in a very exhaustive fashion, one by one, in our ensuing lectures, but to make you understand the essentials for obtaining the patent, wherein we are discussing about the substantive requirements for obtaining the patent. The very first requirement, as I discussed, is the requirement that your subject matter must not be expressly excluded by the Patents Act. The another requirement that there has to be a novel thing in your or novelty involved in your work. The third requirement is that it must be non-obvious, must involve an inventive step in it. The fourth requirement is that it must have industrial application, ensuring its utility. Friends, if your work cannot be used industrially, cannot be applied industrially, or if it lacks the utility with respect to its application in an industry, it cannot be granted a patent protection. I will discuss it, I will describe it in 3-4 sentences, viewers. If somebody creates some work, some invention I call, and seeks a patent protection over that work, applies for the patent protection in the patent office, but that particular work is of no use at all. Suppose that particular work is of no utility at all. It has got no industrial application, it has got no utility in terms of its industrial application or to be used in an industry. Then what is the point of granting it a patent? There is no use of granting it a patent. It would be a very superfluous patent given or granted to that kind of a thing. So that is why it has been taken care by the Patents Act in its purview that there must be some utility of the patent sought by the applicant, or there has to be a utility involved in the patent if it granted by the patent board or patent controller or the government agency. In India, it is controller of patents which grants the patent, which confers the patent protection, by seeing first of all these substantive requirements to be satisfied by the applicant. And the applicant must also approach the controller first of all by satisfying himself on all these issues, by satisfying himself on all these substantive requirements. The moment he is satisfied that this particular work, as I repeat again and I reiterate purposely, that this particular work is a work which is not expressly excluded by the purview of the Patent Act, or which is not expressly declared as non-patentable work. First. Second, that it contains some novel feature in it, or it is novel in nature. Third, which I call a very rigid requirement, which I call a very stringent requirement, which is a very high level threshold requirement, is the requirement of non-obviousness. Fourth, that it must own some utility, it must have a feature of industrial application in it. If you have this satisfaction by analyzing your work on these parameters, on these 4 parameters, I would like to play the slide again to my viewers. Kindly put that slide again. This slide shows these 4 substantive requirements are to be checked and to be seen. If any one feature or a facet is not fulfilled, in that case the patent cannot be granted to the person seeking the patent. And in case if it has been granted erroneously, kindly note that viewers, if in case the patent has been granted erroneously, not in compliance of these requirements, that patent may get declared by the court of law, because the controller of the patent grants the patent, does not declare its validity. No patent which has been granted is declared valid by the patent office. They just confer it on the person by satisfying themselves on their parameter, on their criteria. Later on, it may be challenged by some other person, some interested party, some somebody interested in that particular work or any other person for that matter challenging its validity. So that validity can be challenged on any of these grounds. You may say that the patent has been granted erroneously because it does not have the requisite novelty. You may plead, you may claim, you may contest in the court of law that a patent has been granted erroneously, it lacks non-obviousness in it, it is of no utility at all. Or you may pick up or invoke the very first substantive requirement while claiming that the patent is granted erroneously, that is the requirement that it has been erroneously granted as it falls under the definition of the non-patentable list or non-patentable subject matter as declared under section 3 of the Patents Act. Viewers, to my understanding, this description about the essentials for obtaining the patent, and which I call substantive essentials for obtaining the patent, is suffice at this level. We will have some case laws on these respective requirements later on. Let us see. But before going or jumping to the another topic, let me take you to another important facet when we talk about the essentials for obtaining the patent, procedural requirements or procedural essentials for obtaining the patent. The procedure for obtaining the patent, friends, is described under the Patents Act, is provided under the Patents Act in many of its provisions. That primarily consists many things, wherein at the first level we see that is filing of the patent application. If you see it superficially, then filing it with the specification to the patent office, with the provisional specification I mean, because it is a case when a person files the patent application notwithstanding the fact that he has not completed his work, he has not completed his invention, but still he is allowed to file the patent application to get the priority right over other applicants. That I will discuss later, but this procedural requirement of filing the application with the provisional specification and later on with the complete specification, then many other procedural requirements in the form of putting or affixing the proper form, paying the requisite fee, going to the proper office for obtaining the patent, filing it at a right time, filing to be done by the right person. These are some of the procedural requirements. These procedural requirements are very important, are highly important. They will be discussed by me later when I will deal with the procedural requirements. But before that, I would like to take you what is a patentable subject matter in India under the Patents Act 1970. As I mentioned that this is the substantive requirement for obtaining the patent, that your work must be a work to be given a patent protection statutorily declared by the Patent Act. And as I discussed the first essential of obtaining the patent, that our Patent Act 1970 does not declare what inventions can be granted the patent, rather it enumerates a list of things which can never be granted the patent, except on one occasion where we find that it is worded positively, it says that this particular thing can be granted a patent protection. I will tell you what is that, but let me take you what are the patentable subject matter in India. Friends, the most important thing to be understood and to be taken care of by the person understanding about the patentable subject matter in the patent law in India is that it means, this subject matter here means object or a thing which are eligible for obtaining a patent or for granting a patent. Object or a thing, in a layman wording it can be called an object or a thing, but in the Patents Act 1970 it is an invention only which is to be given a patent protection or which can be granted a patent protection. It can never be a normal object or a thing. It has to be an invention which can be granted a patent protection. That object or a thing, as defined or discussed in this slide, identified as patentable by this act, is invention only. As I mentioned, and I am repeating it, that it is invention. But not all inventions are patentable. Another thing that I would like to discuss, that not all inventions are patentable. Only few inventions, or only those inventions which are not expressly excluded by the statute, by the Indian Patents Act from its purview, are patentable. What are those? That we will take care of, that we will discuss. But for now, you just understand that inventions which are not coming under the declared statute or not falling under the negative list where some subject matters are excluded from the purview of giving a patent protection, or we can call which are declared as non-patentable inventions. So the one thing that one must know, that the patentable subject matter in India is what? Is invention. The first thing that must be understood by all my viewers, that the patentable subject matter in India is invention, but not all inventions are patentable. Only those inventions are patentable which are to be granted the patent right as declared by the Patent Act 1970, and then they will have to fulfill the requisite qualifications for the purpose of obtaining the patent. Let me take you to the meaning of the invention. You must be thinking that what would be called an invention. If the Patents Act 1970 declares the invention as the patentable subject matter, then what is the definition of the word invention? Friends, the word invention defined under section 2 of the Indian Patent Act reads, it means a new product or process involving an inventive step and capable of industrial application. But the reader does not clearly get the idea what is the meaning of the invention defined in this context under the definitional clause section 2 of the Patents Act, because it reads simply that invention here means a new product or a process involving an inventive step and capable of industrial application. But the word invention as such has not been discussed and defined and described. So we must see some of the meanings of the invention which are very popular, which are the dictionary meaning, or which we can call are the meaning to be attributed to the word invention. Let me take you to my next slide, wherein I have described the meaning of the word invention. First of all, we will see that the dictionary meaning of the word invention is something which never existed earlier, something invented or created by the person. That's the dictionary meaning of the word invention. Another is the scientific meaning of the invention, that we will also understand what is the scientific meaning of the invention. Another thing is the legal meaning of the invention, which is defined under the Indian Patents Act 1970, as I told, under section 2, which reads that invention means a new product or process involving an inventive step. Then the meaning for the patent or for obtaining the patent of the word invention, that we will have to elaborate, elucidate in a very exhaustive manner. What would remain the meaning of the word invention for the purposes of obtaining the patent? Because our focus would revolve on only this particular meaning of the word invention throughout the legislation, throughout the discussion relating to the law of patents in India. The moment we will understand the meaning for the word meaning of the word invention in the Patents Act, our job is done, our job will be done. The next meaning, which is a very prevalent or a popular meaning of the word invention, that also we will understand. And the next meaning is the lay meaning, or in the terms of the layman, who understands invention is something created or something invented for the first time, something which never existed earlier, something which never lied before. When we talk about the popular meaning of the word invention, we have many meanings to be attributed to the word invention, wherein a very popular or a very layman style meaning of the word invention is something which is an improvement over the earlier thing, something which is of utility, something which helps and facilitates the person or a worker engaged in, engrossed in that industry. So that is how we can see that there can be many meanings, various meanings, myriad meanings available for the word invention. But for our purpose in this context, when we are talking or discussing about the law relating to patent in India, we will have to zero in, we will have to focus only on the meaning which is a meaning for the purpose of the Patent Act. It cannot be the dictionary meaning, it cannot be the scientific meaning, it should not be the lay meaning or the popular meaning. The meaning that we will finalize for the purposes to be construed later on, or for the purpose of importing it later whenever we encounter or confront with the word meaning, word invention given under the Patents Act 1970, that has to be or that should be the meaning under the Patents Act 1970. Friends, if I would discuss about the patentable subject matter in India, as I mentioned that it is inventions. It is inventions. And what kind of inventions are patentable? Inventions which are not declared non-patentable inventions in the Patents Act. Patentable subject matter is invention and is defined under section 2J of the Act. Section 2J, section 2 is primarily the definitional section given under the Indian Patents Act, defines many intricate words, many words which are to be construed in the similar fashion in the later mention of those words during this reading of this act or in the act. This means, this word invention defined under section 2J means a new product or process involving an inventive step and capable of industrial application. As I mentioned that the word invention is not defined anywhere in the Patents Act, but it is defined as it is a new product or a process. As such, the light has not been thrown on the word invention. For the purposes of the Patent Act, it is a new product or a process involving an inventive step. Section 3 and 4 of the Patent Act, friends, provides a list of non-patentable subject matter. This, together with many other things, we will take up in our next lecture when we will meet next time. I'll be continuing with this series in my ensuing lectures, and the next lecture would be primarily on the patentable subject matter along with some case studies of India as well as of abroad, because in India very few case studies are available when it comes to novelty, when it comes to requirement of non-obviousness, when it comes to requirement of utility. So we will be seeing some judgments of other jurisdictions, but their ratio or their rationale can be imported in India, because as far as the concept of novelty, non-obviousness is concerned, that remains same by and large in all nations except some trivial changes or some petty changes in that. Thank you very much, viewers, and I take your leave now, and I in advance do what? Happy Independence Day to all of you. Thank you very much.
With this note, thank you, sir. Thank you so very much for giving us a very productive session. And as Mr. Ashwin Esewal himself said, that we would be meeting again and we would be discussing further very soon. Till then, take care. Goodbye. Thank you, sir.
Very much. Thank you, Gitika. Have a good day.